Good evening, everyone. I'm attorney Catherine Henry. And depending on which live count I use, the video just started, so I'll say again, good evening, everyone. I'm attorney Catherine Henry. And last night I went to you live to give you kind of an intro on a few different things. And tonight I told you I'd go just into a little bit more detail. This isn't going to be the main question and answer session. I plan to do that probably Saturday, maybe tomorrow. Trying to get into the swing of having a couple of much smaller videos earlier in the week with a longer one that's question and answer later on in the week. So trying to get used to that anyway. Okay, so basically I wanted to start with ways that I want to give you context. I want to give you information, but I want to give you context for that information. So, let's see. This is terrible. You can't see this. We messed around with this the best we could. Oh, you can see it better on there. Okay. Well, anyway, it still can't see the top, right? Okay, let's see about this. See if I can do it this way. Okay. Okay. So, I don't know that it's going to move. Move it closer? Nope. This way. This way. Okay. That's good enough. All right. So just wanted to go over some basics, some stuff that I take for granted. And I'm really sorry if I ever speak to you in a way that sounds like it's a bunch of legalese or it's a bunch of, just big government acronyms or something like that. I don't ever want to come across that way to you guys. I don't ever want to make it seem like this is stuff that you guys can't know or should not know, because you should. Absolutely, you should. So I do want to make sure that this is broken down as simply as possible. I also worry about if I break it down too much past the point of what I think everybody just kind of understands, then I don't want to seem like that's super insulting to you guys because you already know all those points. So I'm trying to balance that where I want to make sure you have all the information you need, information that I just take for granted, but I don't want to give it, too much explanation for points that everybody's like, well, yeah, we already know that. Thanks a lot. So to boil it down to its basics, something that everyone in government, it seems, has totally and utterly forgotten, all the way up to the U.S. Supreme Court. We don't get our rights from government, period, ever. They don't come from the government. Where do they come from? Rights come from God. Now, did I just get that from the Bible? Well, yeah, okay, it says it in the Bible, but guess what? It says that in our U.S. Constitution and in our state constitution. So we established our U.S. Constitution to, quote, establish justice and secure the blessings of liberty to ourselves and our posterity, end quote. That's the U.S. Constitution preamble. We have blessings, capital B, of liberty, capital L, that were given to us by God. So we created the Constitution to secure those blessings of liberty. In our state constitution, it says that we established our state constitution to, quote, secure the blessings of freedom from Almighty God, undiminished to ourselves and our posterity. The blessings of freedom from Almighty God, undiminished to ourselves and our posterity. That's in the state constitution. So, although I do believe in the Bible, me telling you that our rights come from God isn't something that is, extraneous to the concept of government. It is literally the foundation of our U.S. and state constitutions, and therefore our U.S. government system and our state government system. After that point, we then see the U.S. Constitution and constitutional federal statutes. That's next. Okay, so what's the most important? Well, the rights that come from God and God's law, the U.S. Constitution, and constitutional federal statutes. After that, you have the state constitution. So our Michigan state constitution is after the U.S. Constitution in terms of supremacy, in terms of what is controlling. Let me see. I might need to go like this a little bit. Okay. State laws come after the state constitution. State laws are only created in two ways. You have your legislature that creates state law. That's the normal way we think about it, right? You probably heard the song in your 4th grade about the bill and how the bill becomes a law. But we also have in the state of Michigan something that's unique. I'm not entirely certain that we have the only version of this, but it's fairly unique in terms of the freedom with which the people can do something like this, to the extent that they can do something like this, which is to have the initiated legislation. That's actually what the 1945 repeal is based on. The ability to have initiated legislation, where we can totally go around the legislature and initiate legislation or laws on our own, as long as we get enough signatures and then we get enough votes. There's a blended version where you have the signatures and then it goes right to the legislature, and then the two of them together can enact law without ever going to the governor. Otherwise, typically you have to have a majority of the representatives and senators that vote on it, and then it goes to the governor and the governor signs it. Or you have a majority of the senators and representatives that vote on it, it goes to the governor vetoes it. It can go back, and you'd have to have a supermajority or 2/3 vote of the legislators to approve it at that point, and then it becomes law. So those are the two pieces of things that are actually law. The interesting thing is that in our state law, we have something, let's see, hopefully you can see this if I do it big enough. MCL 8.8. MCL 8.8, Michigan Codified Law 8.8. That's a very low number. A lot of the stuff we've been talking about is, in the hundreds. So 8.8 tells us that it's been around for a while. So what is 8.8? 8.8 tells us exactly what laws are. That is the law in Michigan that tells us what laws in Michigan are, kind of a circular thing. But it tells us that we have constitutionally enacted legislation or constitutionally initiated legislation that's done by the people that we just talked about. Those two things. There's a third thing in there. And that would be done under Article 5, Section 2 of our state constitution. That is where you can have a certain kind of executive order that, number one, only serves to reorganize the executive branch. It doesn't serve to rule the people at all, ever, no exceptions. Number two, if the governor wants to utilize one of those executive orders, she then has to present it to the legislature and allows them, see, and I always forget the number. It's either 60 or 90 days. I do believe it's 60 days that the legislature then has to decide if they are going to disapprove of that executive order reorganization. She actually did a couple of those this year, 2 or 3, I think. There was something, an executive order from 2011 that she was essentially trying to rescind to reorganize a portion of government. And then more recently, there was one from 2016 that she was rescinding. Both of those, I believe, were executive orders that came, well, after Executive Order 100. So at any rate, that's what state laws are. And then, hopefully you guys can see that, all these blue things here, they're what are not laws in Michigan. Administrative rules and regulations. That's a long story, but basically what it points to is this right here. These are the two ways we get laws. So the legislature can't just say, well, I'm going to give you the ability to make laws for me. No, they can't do that to administrative agencies. They can't do that to the governor. They can't do that to anyone. Okay, so their ability to make law is theirs and theirs alone, and it says so in our state constitution. They can't give away the right to make laws. Just can't happen. So administrative rules and regulations are not laws. Executive orders are not laws. The only thing that is deemed law of an executive order is when the governor is reorganizing the executive branch under Article 5, Section 2 of our state constitution, and she presents that reorganization executive order to the legislature, and then the legislature has taken the, 60 days that they are allowed under the Constitution to decide whether they are going to disapprove of that, and they decide not to. Then, at that point, that executive order can then have the force and effect of law, of a law that is reorganizing the executive branch, period. That's it. But regular executive orders, nope. It's not a thing. You can't have executive orders to rule the people, period. But what about MCL 10.31 and MCL 30.403? Well, those are the two statutes that the governor is using, right? The 1945 law is 10.31. The 1976 law is 30.403. Both of those laws say that as long as she has declared a state of emergency, she is allowed to use executive orders to essentially rule the people, to control the people, to reduce the risk of injury to person or property because of some sort of emergency. I agree that that's what the statute says. Doesn't matter what it says, though, because if a statute, if a law does not comport with what the state or the U.S. Constitution says, it doesn't matter what it says, it's not enforceable. So when we have executive orders that are criminalizing behavior that was not properly criminalized under the normal legislative process, that's not constitutional. When we have statutes like the Freedom of Information Act, or even fire codes, or the Open Meetings Act, that our governor, through executive order, says, I'm going to go ahead and all those laws that I just talked about, we're just going to cross those off like those don't even exist. That's not okay. How about all the ways that the governor has tried to do this? She is literally telling everyone, wear a mask, it's the law. No, because your executive orders are not law. They're literally meaningless pieces of paper. They do not get to rule us at all. I would love to be able to debate this issue on the steps of the Capitol with either the governor, who is supposedly a licensed attorney, or the attorney general, who is also supposedly a licensed attorney, yet they don't seem to understand the concept that executive orders are not law. These are not the kind of executive orders that are in Article 5, Section 2. And if you have a state law where the legislature of 1945, or the legislature back in 1976 said, you know what, Governor, we're going to give you the right to be king or to be queen, and you can just decide everything for us. It doesn't matter. I totally disagree with the analysis that the governor and the attorney general have been using to say how she can do different things within that statute. And no matter what, the law is very clear that even the law, as crappy as it is, it very clearly says that after the 28th day, she does not have any right to issue these executive orders anyway. So the unconstitutional law itself says, nope, you're done. She doesn't care about that. So, this is getting into that 1945 repeal. Okay, we can get rid of that, which basically stops the issue of the 28-day problem, supposedly. But she's creating all these new executive orders and redeclaring states of emergency and states of disaster and everything else. So, Mike, am I boring you there? At any rate, our governor and our attorney general, and apparently the Court of Claims, they need to understand that no matter what the law says, if it does not comport with and comply with the state constitution, it's not a valid and enforceable law. It has to comply with the U.S. Constitution. Any law that does not comply with the U.S. Constitution or the state constitution, it's like it doesn't even exist. It can't. Because laws can only happen within the context of the Constitution. These two things, the U.S. and the state constitution, are literally the contracts that we created with each other as the people to say, okay, we're going to come together, we're going to live in this land, in this territory together, to have a society where the sole purpose is to secure the blessings of freedom from Almighty God. That's what it says in our state constitution. And in our U.S. Constitution, to establish justice and to secure the blessings of liberty to ourselves and our posterity, right? So that is the purpose that we're creating government in the first place. And how do we do that? Well, anytime you have any kind of organization, you have some sort of a contract, right? You have a deal you're striking, you write it down in a contract. Whether you have a multi-member LLC or you have a whole corporation and you have your articles of incorporation, that's essentially a contract where everybody has come together and they're putting their name on the dotted line to say, yep, this is how we're going to form this particular organization. We formed our country, our entire country, on a contract, the U.S. Constitution. Nothing else can stem from that unless it actually comes from the U.S. Constitution. If the government is not given a particular power under the U.S. Constitution, then that power doesn't exist. The government can't just create its own power, and we have allowed it to do so for far too long. Same thing with our state constitution. Now, by the way, the 10th Amendment to the U.S. Constitution says that any powers not specifically given to the U.S. government belong either to the states, respectively, the several different states, or to the people. To the people, right? So then we look at our state constitution. Well, I would say my favorite clause is starting to become Article 1, Section 23. Why, might you ask? Well, because Article 1 is all about our rights. But Article 1, Section 23 tells us that just because we listed other rights in there, we have the right to bear arms, we have the right to free speech, we have the right to free exercise of religion, we have the right to not have our contracts impaired, we have the right to, oh my goodness, I can't remember all the ones I just said. It's been a long day. It's been a long week. The point being, we have numerous rights that are written down here in the state constitution. Number 23, Article 1, Section 23 says, regardless of however many rights we've enumerated or listed in this state constitution, that does not mean those are the only rights we have. Because our rights come from God, So anything that God has given to us is still there. It's just that we have chosen to specifically protect certain rights that we felt were at issue or in danger of being trampled upon. Never in a million years would our founders, either our founders of our entire country or the founders of our state government, never in a million years would they have thought that they would need to put in there that we have the right to breathe fresh air without having to wear a mask, which literally is not going to stop coronavirus anyway. Never. So the fact that they didn't list it in there doesn't mean we don't have that right. We have a right to breathe that fresh air. We have a right to not have our faces covered up. We have a right to be able to just exist freely and have our own identity, our own facial expressions, and our own ability to speak in public. That exists, regardless of whether it ends up being put in or taken out of a particular constitutional document, because those rights come from God. So, again, just kind of something that I've taken for granted throughout the years, and something that it was just pointed out to me recently in a couple different ways that people really didn't understand this. And so I want to make sure you guys all have that information. It's very important. Don't let anyone in government tell you otherwise. You exist and you get your rights from God, period. And from there, we then create our U.S. Constitution, and this supersedes anything else that ever happens in the U.S., period. Bottom line, no exceptions. Never, ever, ever any exceptions. To the extent that the U.S. Supreme Court has decided certain cases with some latitude towards the government or leniency or, any kind of thing like that, we don't get our rights from the U.S. Supreme Court. We get our rights from God. Sometimes the U.S. Supreme Court is going to get it wrong. And to the extent that they're forgetting we get our rights from God, well, they're wrong. So our U.S. Constitution is supreme over everything. Then we have our state constitution. That is supreme over everything else here. And then you have state laws, those two ways that we talked about, or that rare exception of the Article 5, Section 2, which is just the governor reorganizing her own executive branch. That's it. Not the power to regulate the people. Not at all. In fact, we can look at MCL 8.8, the law that says what laws are in the state of Michigan. And by the way, when we are making laws, there's quite a few things that have to happen. Let's see. Off the top of my head, I want to say it's Article 4, Section 27 that says the governor has to wait 90 days before she tries to enforce any new law unless the legislature has voted in a supermajority to give it effect. They haven't done that here. Let's see. Maybe I don't have to go off the top of my head. Maybe I have it written down here. Yeah, there we go. Article 3, Section 2 says there's a separation of powers. This is our state constitution that I'm referencing here. There's a separation of powers that specifically prohibits any executive branch member, like the governor, from exercising any powers that properly belong to, say, the judicial or legislative branches. It says you can't do it at all. So the governor, who is on the executive branch side, she cannot exercise legislative powers to make laws, period. Her job is to enforce the laws that people have created or the laws that the legislature has created, period. Let's see, Article 4, Section 22 says that all legislation shall be by a bill. Doesn't say executive order. It says all legislation, all laws shall be by bill. She hasn't created or drafted any bills. She's just created a bunch of executive orders. Laws cannot be created with more than one subject. That is Article, oh, look at that. I have a typo. Article 4, Section 24 of the state constitution. You cannot have a law created that has more than one subject, which is one of the very things that on April 30th, the governor did a special Thursday news conference to tell us that she was going to basically very happily refuse to sign Senate Bill 858 as it got placed on her desk because that bill was unconstitutional. And boy, it certainly was. We don't even want to talk about all the ways that that one was unconstitutional, but one of the main ways she talked about was that it talked about a variety of different subjects. And so it was unconstitutional. The legislature can't do that, and neither can the governor. So when she has a stay-at-home order that talks about what you can sell and what you can buy and where you can drive and how many people can be in your building and whether you have to wear a mask or whether you have to put tape on the floor or, you know, any other wide variety of things that she thinks she's going to throw all into one particular executive order, if it was truly a law, it would have to comply with the requirements of the law and not have all those subjects in one bill. But let's not forget that Article 4, Section 25 of our state constitution says anytime that you are going to amend any part of the law that's already on the books, you have to write or rewrite the entire law in that new law so that it's clear what you're changing, what you're adding, what you're taking away. Kind of like with the constitutional amendment, the Restore Freedom Initiative petition has the same requirements that when you are going to be modifying any provision of the state constitution, if you're taking something, you're going to put a cross through or strike through into that text and reprint that text. If you're going to leave the text alone, then it would appear like this, where you have normal capitalization. If you're going to add text, then you would do all capital letters. Like that. So whether you're drafting a constitutional amendment or whether you're drafting legislation, same thing. If you are going to amend a law, so for example, FOIA, the governor thought that she could, with a signature or two, she could just modify the entire Freedom of Information Act like it doesn't matter. And in doing so, she failed to follow all these other procedures, including the constitutional requirement that if she's going to modify a law, she has to include the entire text of the law in this executive order to show us exactly what she was amending. And I think I did put my husband to sleep talking about this stuff, so hopefully I didn't put you guys to sleep over there. Yep, it's Article 4, Section 27 that says that she has to wait 90 days before enforcing any new laws. And let's see. Of course, there's Article 4, Section 39 that specifically spells out that when we are in the state of emergency, our state and local governments have to continue to function normally. It's in our state constitution. That's right. When we are in a state of emergency, it literally says, period of emergency. That Article 4, Section 39 of our state constitution requires state and local government operations to continue, despite our governor shutting down most of our governmental offices. So, at any rate, we get our rights from God. They are protected in the U.S. Constitution. Any rights that we did not specifically, any powers that we did not specifically give to the U.S. government in this Constitution are either reserved to the state government or to the people. Because don't forget, Article 4, Section 4 of our U.S. Constitution requires, guarantees is the language, guarantees to us a republican form of government where the people retain control of the government, and they simply elect representatives to go and exercise that power. So that's guaranteed to us. After the U.S. Constitution, you have that state constitution, and then anything, any kind of state law at all, whether it's created by the people or by the legislature, it has to comply with all the requirements of the state constitution and all the requirements of the U.S. Constitution. If it doesn't, it's non-existent. One easy example of that would be to reference Marbury versus Madison. Any law that is repugnant to the Constitution is void. It's as simple as that. So if you have any kind of administrative regulations, those are not constitutional unless the legislature voted on each of them. Executive orders, the legislature hasn't voted at all on those. Those are not constitutional at all. Nothing about it is constitutional. There's no way to make them constitutional, especially not the ones that she's done up, because they talk about so many different subjects. And if they voted on it, they would have to get a supermajority to vote in favor of them to even give them immediate effect. Internal operating procedures that the government has. That's not constitutionally permissible as a way to regulate the people. Personal preferences. That happens a lot at the local levels of government. I could care less what a particular governmental employee's personal preference for something is. If it's not required in the law, the government can't use it to regulate us. Period. And government forms is another one. Well, it says on this government form that we have to do. I really don't care what a government form says. If it's trying to impose a requirement over and above what the law actually requires, then it's not a requirement that's legally enforceable upon us. And let's not underestimate this enough. If there is a law that is not constitutional, it violates our rights in any way, that part is definitely not constitutional. It is not enforceable, period. So I wanted to point out that at the beginning of this, I gave you guys a link to the copy of the brief that I most recently filed with the Michigan Supreme Court. Now, that is not in the legislature's case against the governor. What that is actually the legislature did have their hearing in the case that they sued the governor. They had their hearing with the Court of Appeals on Tuesday. And it was interesting to listen to oral arguments. It was done by Zoom. Needless to say, there were a lot of technical difficulties. In fact, it might be fair to say that the only person that did not have any kind of technical difficulties in that whole entire thing that had any kind of speaking role at all was Attorney Michael Williams, who is the legislature's attorney. I think every other attorney, every other judge involved had some kind of technical difficulty at some point. But anyway, they had that hearing. I want to say that the Supreme Court has required that the legislature, that the Court of Appeals comes out with their decision on the matter by August 21st. And then the parties would have the ability to appeal that, of course, to the state Supreme Court. In the meantime, however, in the end of June, yes, I believe it was on June 30th, well, let me back up and say, I want to say June 16th, there was an order from the U.S. District Court, so the federal court, the U.S. District Court in the Western District of Michigan, Southern Division, where some private individuals who were needing medical care and some doctor's offices and whatnot actually came together as a connected set of plaintiffs. They filed a lawsuit against the governor in federal district court. On about June 16th, the federal district court judge in that case said, you know what? I need to not handle this case just yet. I need to hear what the Michigan Supreme Court says about the constitutionality and essentially enforceability the legality of these executive orders within the context of the state constitution and state law. So that was called certifying a question. They certified 2 questions, one related to the state constitutional aspects and the other related to, after April 30th, did either the 1945 or the 1976 or both, did they allow for these executive orders to continue being written? Of course, the answer is no. But those 2 questions were certified to the Michigan Supreme Court, and I want to say it was June 30th that the Michigan Supreme Court came out with an order that said that the plaintiff's attorney has 21 days to file a brief in their court. So the plaintiff from the federal court case did file their brief, and then from that point on, I want to say that court order said the defendants, it was the governor, the attorney general, the Michigan Department of Health and Human Services, there might have been a 4th one, but anyway, those defendants were given 14 days, I believe, to file a brief. Their brief was due Tuesday, but they had requested a 2-day extension, and so they received that, and they actually had the 2-day, they actually had their brief filed, at least I believe from the Attorney General's office, was filed today on August 6th. So my brief was filed, Mike, was it yesterday or the day before? My brief was filed yesterday in the Michigan Supreme Court on this case. And in theory, I should know in a couple of days whether the Michigan Supreme Court is going to accept. Yeah. In theory, in a matter of a couple days, I should know from the Michigan Supreme Court if they have accepted my brief, as well as there was one other amicus brief that was filed. I believe it was by Attorney Kerry Morgan. So he has similar arguments in a lot of ways, but pretty much gets there from an entirely different angle. But nonetheless, he was the only other amicus brief that I have seen come through. And then the oral argument on those matters, I want to say, is scheduled for September, I think. I did ask the Supreme Court if it's possible for me to argue these cases, or argue these points on that particular case, because I have been listening to the arguments that have been presented, at the Court of Claims level, at the Court of Appeals level, at the variety of levels that are happening across our state where these issues have been coming up. And the attorneys on these cases have been doing a good job. The problem is they are confined to arguing things that are going to benefit that particular client. So, for example, Michael Williams, he's the attorney or one of the attorneys for the legislature. Well, he has to make sure his argument complies with, obviously, law and whatnot, but he's supposed to present the arguments in a way that is most favorable to his client, which is the legislature. Well, what about the people? Where's the people's voice in all of this? Because one of the main arguments being made by the legislature is, well, the governor did wrong because she took away our right as the legislature to rule the people in this way. And so if we're going to create kind of, various kinds of requirements upon the people, if we're going to require masks or contact tracing or anything like that, then it's us, the legislature, that gets to do that. Well, no, nobody gets to do that. The legislature does not get to go over the state constitution or over the U.S. Constitution or completely ignore that our rights are given to us by God. The state constitution, the U.S. Constitution, they do not allow for those kinds of things. So the legislature, the judicial branch, the executive branch, it doesn't matter. None of them have the right to do that to us. So I've asked the court to allow me to bring directly to the Supreme Court the voice of the people, to be able to participate in oral argument. Typically, that does not happen. Typically, amicus parties are not afforded the ability to present an oral argument, even if they do have a brief that has been accepted by the court. But hopefully, So pray for that. And hopefully we'll get that argument in front of the court. A lot of pieces there that should be argued in front of the court. So anyway, do make sure, though, to take a look at that brief that I filed. Am I perfect? Absolutely not. I'm definitely human, and you might very well find mistakes. But it would be helpful for you to review it. There's a table of contents. Yeah, you can't really see this. There's a table of contents at the beginning. If you go to the PDF version that I put online, it should be, if you click the, depending on your PDF viewer, there's a, what do you call that? The bookmark section. And so if you click that, there is a bookmark to each one of those pieces there. That's actually required under Supreme Court rules. And then this is a draft where I ended up changing the pages, but all the rules and statutes that I reference are in there, and it says what pages, the constitutional provisions, and then the various cases that I've referenced, which is continued. There's these two questions that I addressed, which are the questions that were certified by the U.S. District Court. And then I have my introduction and my statement of interest, kind of explaining why I was writing this brief. And then it goes right into the argument that I presented. So I talk about the standard of review because oftentimes this is a huge thing. If any of you heard me on the Bradley Dean show this week? Last week? I don't know. I think it was a couple days ago. Anyway, he had me on the show to talk about a variety of different things related to this. And one of the points I brought up was that we often will look at cases and talk about case law. Law is not made by judges. Never has been, never will be. Law is made by the people or the legislature. So judges are not there to make law. They're not there really to interpret the law. They're there to simply say what law is there that applies to the given situation. Period. So the standard of review needs to be, well, let's look at what does the Constitution say? Period. If there is a statute on point, okay, what does that say? Period. So anyway, that's what that part of the argument is about. And then this in pari materia, a phrase that you might have heard a lot these days. That particular phrase is talking about how when you have two statutes on point that are on the same topic, they have to be read together. We don't get to pick and choose here. That's not how this works. Also, reasonable statutory construction just talks about the rules of how the courts are supposed to look at statutes and read them together. And some people that have, know a little bit about the law and not enough so that they get to the point of really being dangerous about it. You might have heard people talk about 30.417D and how it says that it can't modify the rights that are given to the governor under 30.10.31. That's not what it says. In fact, that particular point was brought up by one of the judges in the Court of Appeals hearing on Tuesday. She kept asking Attorney Michael Williams about, well, but how can you make your argument on that point when the legislature made it perfectly clear in 10.31 that, in 30.417D, that nothing in the Emergency Management Act can basically abrogate or diminish the rights given to the governor in MCL 10.31. And he argued the best he could given who the context of his argument would work for, right? The legislature. But the main point is here, all the law says is that the Emergency Management Act shall not be construed to limit, modify, or abridge the authority of the governor to proclaim a state of emergency. Period. And it doesn't. It doesn't stop her from proclaiming a state of emergency. It does, however, have some very specific guidelines and requirements for her to keep an emergency going. But regardless, whether we're looking at 10.31 or 30.403, either one of those statutes, to the extent that they give the governor the right to rule the people by executive order, can't happen, because it's not constitutional to have a governor making laws. Can't happen, period. So no matter what the law says, that part of it violates the state constitution, so that part of it, not enforceable, ever. And we don't need to go up to court to figure it out. We don't need to wait for the judge to say, yep, you can exercise your rights, because quite frankly, our rights come from God. Which kind of goes into the constitutional separation of powers. That's the next section I talk about in here. And there's an explanation about how even in times of emergency, the government does not get any more power than what it was given here and here, period. And we do not have any of these rights taken away simply because it's a time of emergency. Think about it. It's almost always going to be a time of emergency. We're always either at war with another country or we're at war with ourselves. There's a pandemic, or there's the 2017, 2018 flu issue that was happening, the epidemic there, or the war on drugs, or, the rioting and stuff that's been happening, and all that. You can go on and on and on and on. There's always going to be some sort of an emergency. That doesn't give the governor or the government in any kind of capacity any more rights or powers than what it originally had, and it doesn't take away our rights, period. And then I have the conclusion in there. And I want to point out to you that, I want to say it's the 14th Amendment, but I don't have that part right in front of me. Well, we'll talk about that at another time, I guess. Anyway, look at your rights. Look at your rights. Look at what limitations are placed upon the government. Do not let something continue to happen simply because it's just been happening that way forever. I don't care. I don't care how many years something has been happening. If it's been happening unconstitutionally, we need to stop it, and we need to stop it now. We do not have to say, you know what, we waived that right. We just won't ever argue about the constitutionality of something because we've let it go on this far. No. If it's unconstitutional, we have a duty to stand up and stop it now. So, like I said, I wasn't really going to ask or answer any questions. Let me see if there's any. Executive directives. Executive directives, executive orders. Executive directives are not even in the Constitution. Executive orders, Article 5, Section 2, under that very limited circumstance are in there, but executive directives are not specifically given any kind of power in the Constitution. I want to say the 1945 and the 1976 law talk about the governor being allowed to issue executive directives to the extent that they're trying to regulate the people, to the extent that those directives would be deemed as enforcing any kind of requirement upon us, the people. It's considered a law, and because it was not enacted by the people or by the legislature, it's not enforceable. It's not constitutional, period. Yes, the governor definitely should be arrested, but yeah, sheriffs have to do the right thing. They have to arrest her, absolutely. Who has the power to stop her? All of us have the power to stop her. All of us have the power to stop her. What is it going to take to stop her? Other people standing up. Standing up. It's going to take 425,059 signatures on a petition that says enough is enough. It's going to take every single person that's around the state of Michigan emailing the governor's office, emailing the attorney general's office. It's going to take everybody communicating in that way to let them know this is not okay, and we're not going to be quietly obeying all of these illegal and unconstitutional executive orders anymore. Period. And yeah, criminal charges should definitely be on the way for any of those government officials that think that all of this has been okay or that it's enforceable. If for nothing else, they could be hit with a 42 USC Section 1983 civil claim where you can get damages as a plaintiff, but also 18 USC Section 241 when they are conspiring to infringe upon the rights of citizens. That is a federal crime where they can receive serious prison time, or in the case of those nursing homes, they could even be given the death sentence for that. And my contacts don't work at this hour. Well, it wouldn't be 18 USC Section 242. That's on the basis of one of those protected disability classes, or not disability, but that's on the basis of a protected class that's identified in the statute. But 18 USC Section 241 is trying to deny anyone of their constitutional rights. As long as you are conspiring, as long as it's a conspiracy and there's two or more individuals that are conspiring to take those rights, those individuals can be held accountable. Absolutely. Call every sheriff then. For those of you constantly saying basically that I'm not giving you enough answers, I'm one person. You're also one person. Pick up the phone and contact every single government official every single day. Contact your sheriff. Contact the Attorney General's office. Contact the governor's office. Email them. Break the email server by emailing them so many times and having every single person in your community, in your circle, in this state that you know, have every single one of them contacting them by email, telling them all these provisions, laying this out and telling them this is unconstitutional. What you are doing is a crime. Anyone, I don't care if they're on the local school board or they're on a local city council or all the way up to the attorney general or the state legislature or anywhere in between, any single person who is conspiring in that manner to stop people from enjoying their constitutionally protected rights is guilty of 18 USC Section 241, period. So write them all and tell them how they can be held accountable. Absolutely, every single day. Do that until it gets done. But put the pressure on your sheriffs. Let them know that you support them in stepping away from that tyrannical regime, but also let them know that you expect them to stand up and do something about it. Absolutely. We already know there's at least one jail in the state of Michigan that is willing to house the governor if she is arrested legally. Absolutely. And then we need to have the trial. Absolutely. So the brief is in a link at the beginning of this post. There's just a link right to the website that has, it's the direct link to that specific part of the website that has the brief. If any of you have any kind of other, like the e-filing access, you'll see it that way too. The website also gives a different version that has the brief and the motion and all the exhibits that I filed. Those were separate PDFs filed with the court. I just have them all as one PDF available to you guys. Those are exactly the same documents that were filed. They just don't have the timestamp on them because I blended them for purposes of uploading those before they got the timestamp on them. But the other one I shared with you online and in this particular thing, it has the timestamp and everything. Okay, I honestly can't see any more of my contacts. I've about had it. I think I see somebody in there said something about sending something to me. Just remember, I don't see Facebook Messenger. I literally cannot open Facebook Messenger. I have not been able to for, I think it's 3 months now. So if you've sent me anything, May, June, July, Facebook Messenger, I have not seen it, and I don't think I'll ever be able to see it. Also, I get thousands of notifications every day on Facebook, so if you're tagging me in something or you're posting to my wall or whatever, I see maybe, I'm guessing at this point, maybe 10% of what is sent to me or tagged, you know, that I'm tagged in or anything like that. I respond to what I see, but oftentimes I don't see it. So just keep that in mind. If you need to reach me, going through the website is going to be the best possible way, depending on what you need. There's a contact us page, there's a get involved page. Both of those will be able to direct you exactly where you need to go so I can help you the fastest. And I don't see any more questions here. If I am missing a particular question or quite frankly even comments, I can't see anymore because my contacts have quit. This was supposed to be my short video though, and it's an hour. So thank you so much for everybody who is listening, everybody who's trying to stay engaged and stay active out there. Read that brief that I filed. Read all the constitutional provisions and the statutes and everything that I put in there. Read it, look them up for yourself, and then when we do the question and answer, the real one that's supposed to be the question and answer session in the next day or two, then you'll be prepared to know exactly what to ask me, and I'd be more than happy to go into those details. So hopefully I can still sometime tomorrow do some sort of shorter version of this to let people know what's out there. And by all means, I am paying attention to the questions that I see. I want to make sure that you guys have the information that you need. But do know, I am only one person, and if there was a Staples Easy button to fix all this, I would have pressed that button a long time ago, because I'm tired. But I'm going to keep fighting as long as it takes to get our freedom back, because that is our job as Americans. That is what we need to do. We need to band together and get this done. So go out there and sign the constitutional amendment petition. That is the grand slam. But it's not going to be on the ballot till 2022. So in the meantime, go ahead and sign that repeal 1945, and then ask Stand Up Michigan to go ahead and get us going on the 1976 repeal. And the Public Health Code, Chapter 333, that has a bunch of scary stuff in there. Ask them to start working on that repeal. One law after another. We can do as many at one time as we want. Let's do it. Let's get this done. Let's get individual laws taken off the books until it's time in 2 years for us to have that constitutional amendment vote, and then we can go ahead and get rid of all this garbage. Clear this up once and for all. Okay? That's what that constitutional amendment is there for. And I should mention, to those of you in Georgetown Township, thank you very much for voting for me. As you probably are well aware, I have not been out on the campaign trail, so to speak, in Georgetown Township. I've been a little busy doing this stuff, but I really appreciate all the votes. I really appreciate all the support, and I look forward to working with the rest of the people that were, well, let me say, there's still a general election. I am not on the board yet. But as the Republican primary candidate in a district that is typically about 85% Republican, it's a pretty good chance that I will be making it through the November vote. So with that in mind, I look forward to working with the rest of the people in that similar position and trying to make sure we are not allowing government overreach or overspending at any level of government. with that being said, I hope you guys all have a wonderful night. And again, I really do thank you for all tuning in. And thank you to my amazing team, Tammy and Colette and Lacey and Mike and Brian and my dad, Bruce, Paul and Frank and Andrea. Oh my goodness. Joe. Mike, who am I forgetting? Did I say Lacey? Did I say Lori? I didn't? Oh, well, Lori. Can't forget Lori. Anyway, every single person on the team, whether I said you or not, I love you all. You're super appreciated. Thank you so much. And I guess for those of you who are on my team, I'll be seeing you bright and early tomorrow at 7:45 like we do every day, Monday through Friday. All right, guys. Have a great night.